Well, hello everyone for my full semester online American Government class and my second 8 weeks American Government class. Glad to have you here today. This is a bright, sunshiny day, February 2nd, Groundhog Day, but we have a beautiful day here in Miami, Oklahoma, where I'm recording this. Again, I'm Jeff Birdsong, your instructor for this class. Chapter 5, Civil Rights. A very important issue, like all of our chapters that we're covering here, and one that's always in a state of flux. Things are changing, and we have to constantly address what are the best ways to ensure that people have fairness in our society. So we have civil rights, rights among groups. So last week, in my recording on civil liberties, we looked at the rights of the individual. And we are all individuals, but we're also members of groups. So within those groups, what equal rights should we enjoy? And so as we look at rights among groups and say that there should be equal rights, then the question would be, what is equal? What is a fair way to determine equality? And this is where the Supreme Court comes involved. They are really the branch of government that has a great deal to do with determining civil rights. So laws can be passed, and then it's up to the courts to determine if those laws are constitutional and determine the correct way to interpret the Constitution. So if you go back, you start to see how these chapters blend in and overlap. So here we're talking about the Supreme Court, which we'll come back to when we get to Chapter 15. We've covered them to some degree in Chapter 4. But then think about Chapter 2, the Constitution. And in that chapter, how brief the Constitution is, the United States Constitution, compared to constitutions in other countries. This then means that it's up to another body, in this case the Supreme Court, to make that determination, what is the meaning of the Constitution. And so some of the recent decisions that the courts have made regarding key parts of civil rights has dealt with changes among states. Think about Chapter 3. For example, you can read about the Voting Rights Act on pages 174 and 176. So the Supreme Court in 2015 ruled against gerrymandering in Alabama. Be sure and look up that term, gerrymandering, how these districts were drawn to help one political party over another or to hurt one group of people over another. And then the Supreme Court in 2013 struck down parts of the Voting Rights Act, and now would allow 9 states to change election laws without federal approval. There had been 9 states, because of their past experiences, that could not change their state laws unless they got the approval from the federal government. And let's keep in mind, Chapter 3 again, federalism, that determining voting laws has been a power of the state government. But some states, because of their patterns and how they determine those laws and preventing some people the opportunity to vote, and primarily this would be in the old Confederacy, they had lost that type of power. Now the Supreme Court in 2013 has given that power back. And part of the claim made by the Chief Justice of the Supreme Court is that we're now in a post-racial society, that we're not thinking in terms of race when we make decisions regarding one another. It's a very fair question to ask, are we indeed in a post-racial society? So we have an African American as president, and does that then suggest enough to say that we're in a post-racial society? Well, there's been some tests and studies that continue to be out there to look at, if we were in a post-racial society, could you then not determine that there are differences in how people are treated in the law, there are differences in how people react against one another, if people are no longer considering race. But a couple of sources here that I have listed on our website to check out and get some information from. The Guardian and 538, both of these sources have determined that police killings that take place that are poorer and blacker than the United States as a whole. And whites killed by police tend to have a weapon, not always the case with blacks. So in other words, is there greater force used against one group of people than the other by the police? Secondly, does there have to be some sort of extenuating circumstance to use that force against one group of people as opposed to another? There's some documentation to suggest that there's a difference in how a policy is carried out based upon the race of the individual. When we think about income inequality, we do see that there are some places in the country where the gap between the rich and the poor is much greater than what you find in other places. This chart is a little hard to decipher, but the suggestion then is that you have some wider gaps of income inequality. It's almost an inverse way of looking at it. But where are the greater amounts of poverty? And we can see in the southeast part of the country. Also, though, let's note that you do see the darker colors where you have a large Native American population in Arizona, parts of New Mexico, the Dakotas, and Alaska as well. But what you do see then is where you have a large amount of poverty is also where you have a large amount of African Americans. So is there still evidence to suggest we're not quite in that post-racial society that the Chief Justice Roberts tends to say? So is this just an ongoing struggle? Here I am recording this during Black History Month, and certainly one of the better-known individuals when we think about black history would be Frederick Douglass, a man who was born into slavery, escaped from slavery, got himself educated, and made this determination that if there is no struggle, there is no progress. So we're still faced with an ongoing struggle if we want progress among people of different racial backgrounds, religious backgrounds, economic backgrounds. And that struggle clearly was very evident to us in our culture when we had slavery, when this was above the ground and we could see slavery, we could see people being sold in auctions and how people were being treated. But it is worth noting that slavery still exists. It's just underground. It's an illegal activity today, and it's still a very profitable practice. And in many cases what happens is, especially for young women, if they're captured and put into slavery, or they put themselves in extremely vulnerable positions as being undocumented workers going from one country to the next. So Time magazine 6 years ago, roughly 6 years ago, made the observation that despite more than a dozen international conventions banning slavery in the past 150 years, there are more slaves today than at any point in human history. So we still have a struggle. Still have a struggle on how human beings treat other human beings. And this has been a struggle in our own country. American Indians were not U.S. citizens until 1924. Women didn't have the right to vote until 1920, and it was a considerable struggle to get that to happen. And we still can look at other groups today and say, are they being treated in a way that's unfair, that are not given the same opportunities as other individuals? And should something be done about that? The disabled, gay, lesbian population, transgendered population, and the aged, elderly. Is this based on either getting too old to be discriminated against or too young? And are there ways then in which we can say this is an unfair discrimination? It is something we're going to point out here, that are there times in which there's actually a discrimination in which we find to be acceptable. For the sake of society, it is worthy of maintaining a discrimination. That's an interesting point, and one that we certainly have to confront. So a key part of our society that started to begin the process of opening up for civil rights and questioning the need for civil rights and implementing civil rights was the Civil War. So Civil War, 1861 to 1865, still the bloodiest war in American history. And from that, you did start to see what was referred to as the Civil War Amendments, the 13th, 14th, and 15th Amendments. So as we can see here with the Civil War Amendments, 13th Amendment abolished slavery, 1865. This amendment is still in some ways referred to in Schenck versus United States in 1919, if you recall from last week, on the case on whether or not a draft should be implemented or people can protest the draft in World War I. The issue there was the people against the draft were arguing that it was like a form of slavery to have a draft. 14th Amendment, equal protection under the law in 1868, 3 years after this end of the Civil War. And then the 15th Amendment, universal suffrage for adult males in 1870. So in some ways, you can look at that history for the United States, 13th, 14th, 15th Amendments, 1865 to 1870. You can almost say, well, we can wrap it up in a bow, and there's the present. It's over. We've got civil rights. But we know in our history, or certainly if you read through this chapter, you can get the sense that that just led to a backlash to the Civil War Amendments, to civil rights. And that backlash came in many different forms. One of the better known forms was segregation, legal segregation within the states, and oftentimes referred to as Jim Crow. So you would have many states. Oklahoma was one of those states. Mostly states within the old Confederacy or states that bordered that Confederacy, like Oklahoma, that would have legal segregation. So you would have, for example, as you can see in this picture, a waiting room for people who were deemed colored, and that they would have to go to that area as opposed to some other area for a building. If it was, say, at a bus station, for example, that would be the waiting room. So legal segregation is the form for, is the more legal term for Jim Crow. We've had some really good books written about this. This is a very powerful book, Sundown Towns, that is documented about the reality that you would have had local communities. Again, think about Chapter 3, in which these local communities would come up with their own policies on who could stay in the town and who couldn't after sundown. So Sundown Town, whites only, after dark. And so that's, again, clearly describing segregation. So you can have civil rights, but not in this town. You don't get to stay here after sundown. We'll turn this into a bonus project and asking you to find factual evidence of a town that was indeed a sundown town. You need a photo or a city ordinance, that kind of evidence to show that this town was in fact a sundown town. We'll have it due on February 28th and have it worth 20 points. 20 bonus points will be added onto your score, your overall point total. So all the parts of the backlash beyond just legal segregation, you had white primary, only whites could vote. Do you view political parties as private clubs? You know, in some ways that was the consideration during this era. The courts have not viewed it that way, that you can't have it as a private club, that there is an opportunity for people to join a political party. If you have one party that's very dominant in an area, then that would then mean that if you're not a member of that party, then you don't get an opportunity to vote. So that's what the white primary can create. Literacy test, you had to be literate to vote, and poll tax, you had to pay a tax to vote. So all of this really limits opportunities for people to participate in the political system. Other ways of describing the backlash to the Civil War amendments. And the courts got in on this too. In 1896, the courts looked at segregation in public institutions, even those that were privately supported, such as a railroad. I mean, if you wanted to get from point A to point B, the best way to do that, primarily in 1896, would have been a railroad. So if you had African American in a railroad car and you say, well, that's not the one that we want you in, you have to go somewhere else, then that's another form of segregation. Even if, as the claim was made in this case, Plessy v. Ferguson, 8-1 decision, so almost all justices agreed that the facilities needed to be separate but equal. And that's a key phrase to remember from the Plessy case, separate but equal. So if you had a different railroad car somewhere, and that's where you would put the black people and put white people in a different car, then you could call it good and just say it's separate but equal. The history clearly shows that it wasn't equal, but there was considerable amount of separation there. So your text points out about organizations, and this is really looking at interest groups, which we'll cover in chapter 11 in our text, that these organizations step forward to try to end this form of segregation. And one of these organizations is still very well known in our society today, the NAACP, National Association for the Advancement of Colored People. It was formed to deal with these issues on segregation. And then NAWSA, I suppose, is how it could be pronounced, National American Women's Suffrage Association, 1890, to stop or give people the right, give women the right to vote. So suffrage is expanding the right to vote. So women did not get that right to vote until 1920. So you can see this organization was working towards this goal for many decades to try to ensure that women would have the right to vote. And so then we look at the issue of suffrage, again, extending the right to vote. The argument against it, which today seems very archaic, I would imagine, for almost everyone, is that women shouldn't be sullied by the grimy details of politics. And so the motherhood should be pure, and so women just take care of the children, they take care of the household, and so they shouldn't have to worry about the details of voting, that somehow it's going to harm women if you let them vote. It clearly is sexist, you know, the idea. Also, maybe women are too emotional when it comes to that, so they shouldn't be given that right to vote. I would wonder if any of these big hats are ever going to come back in style. Kind of figure no would be my guess. But anyway, so these ladies were leading the charge to try to ensure that women would have the right to vote. The process of ending segregation, again, a very long and perhaps continuous struggle even in our lives today. But President Harry Truman, after the end of World War II, desegregated the U.S. Armed Forces. So do keep that in mind. Truman, who was a World War I vet, after World War II, came to his attention that there were African American soldiers that were beaten up and brutalized on their way home. And here they were even wearing their uniforms for the American military and being badly mistreated during that process. And it really got to Truman. And so he began the process of an executive order to desegregate the armed services. And we'll read about the executive orders when we look at chapter 13 in our text. So now the courts are looking at this issue of desegregating the public school system. So we have segregation, we have segregated schools, white children in one school and what was referred to as the colored children in another school. The Brown family in Topeka, Kansas, which was a Union state during the Civil War, their child has to go to the colored school. It's a very treacherous walk for her to have to go. She has to cross railroad tracks, all these things. She's much closer to what's referred to as the white school. So they argue that this is certainly a denial of the 14th Amendment, equal protection under the law. She's not giving as good an education as she can get. And so this part of the arguments that are made against segregated schools. The courts agree, and in 1954, Earl Warren is the Chief Justice. This is an era referred to as the Warren Courts, and the Warren Courts open up greater opportunities to end segregation during that period. So certainly read about that on pages 166 to 167. And the desegregation of schools didn't go easily, and that's certainly brought out as you read through these pages. So on 167, you also get the sense there of during the Eisenhower administration, President Eisenhower And again, think about what is the role of the federal government, right? We've covered that, chapters 2, chapters 3, chapters 4, probably every chapter that we'll cover, that will be an issue. So his view that it was a role of the federal government to bring in U.S. troops, airborne troops, into states like Arkansas to ensure that African American students would be able to go to the desegregated schools. And so there you can see some sense there of his interpretation of what his job was to do and what it meant in leading to the changes in our society. But what was most important to ensure that this would happen, so you could have these laws, you could have these interpretations by the courts to end segregation, but were they enforceable, and how much change really occurred? And so it's an interpretation by the courts, important, but if you don't have other elected officials, if you don't have elected officials in states, governors, attorney generals of the states that essentially don't follow along or just drag their feet after a Supreme Court ruling, it may not be that effective. And so this is where you need Congress to support it and the President to support it. And so here you have the Civil Rights Act of 1964, where you have President Lyndon Johnson signing that law, signing that bill into law. You have Dr. Martin Luther King, who was looking on and supporting this. And this is an idea of saying we're going to have the legal teeth behind it through the Congress and the presidency to say that we're going to begin the process of ending segregation in our schools. And so certainly read over pages 169 to 174 in your text, the changes made by the Civil Rights Act of 1964. End discrimination in public accommodations, end discrimination in schools, outlaws arbitrary discrimination in voter registration practices. But there was a challenge to this, and the court case was Heart of Atlanta Motel versus the United States in 1964. The Heart of Atlanta Motel, the argument there was that this is an intrusion by the federal government into state practices. These are private businesses. There is not then the right of the state, of the federal government to tell them who can or cannot go into their motel. And so that was the argument made by those that represented this motel. They wanted to keep this motel segregated, whites only. They lost the case, and they lost the case, again, think about Chapter 3, the Commerce Clause. The Commerce Clause would state that it was the power of the federal government to regulate interstate commerce. And if in the process of regulating interstate commerce, it was deemed to be in the best interest in that process to end segregation, then it was constitutional. After all, the Heart of Atlanta Motel was located on a major thoroughfare, roads that would go by the motel, that people would have access to that motel. And those roads, of course, were financed and maintained by taxes in which everyone had to pay, including people who could not stay in that motel. And so that was deemed to be a violation of law, 14th Amendment, and also, of course, then the regulation of the Interstate Clause, Interstate Commerce Clause. Let's turn our attention to women's rights. So this is also a key segment there in the text, and looking at what rights there should be for women. Women throughout a good portion of our history had very limited rights. I mean, were essentially viewed as property, had very little means of being able to represent themselves in court. Their opportunity to divorce a husband, for example, very limited opportunities there. And in fact, in some ways, perhaps you can even look at the images of women and were they even in control of their own bodies if they had to wear clothing like what we see here. It seems like it's, by the very nature of the clothing, it's restrictive. And so it's restricting what women can do. And that's almost symbolic of the limitations for women throughout a good portion of our history. So one of the ways of looking at this is to say, are there times in which there's deemed acceptable forms of discrimination, not only for women, but for people of different races and ethnicities? So for women, as you can see, there's an intermediate burden of proof, partially on government and partially on the challenger. So if a woman is to make an argument that she's being discriminated by some particular policy or law, the burden is in part on her. And that we can see with race and ethnicity, there's a strict burden of proof on the government. The government has to prove that it's an acceptable form of discrimination against a race or ethnicity. We can, I think, understand from that in most cases it's not going to be acceptable to discriminate against race or ethnicity, but there may be some rare circumstances in which it would be acceptable. There's a greater possibility of an acceptable form of discrimination against a woman. Where this probably comes into play more than anywhere else in terms of discrimination against women would be on particular tests where consistently women may not do as well as men, just based on the body structures of the women and versus the body structures of the men. Firefighter tests are oftentimes one of the issues that's raised there. Upper body strength is just necessary to be able to do the job of a firefighter, to be able to carry a large amount of weight up some stairs or downstairs, rescuing people, for example. So in order to do that, you have to prove that you can pass the test. And if you can't pass the test, then you don't get to be a firefighter. It's discrimination. Then the question is that an acceptable form of discrimination? And it has generally been viewed as an acceptable form. It makes sense that you have to pass this type of test to be able to do this type of job. This is also, of course, some of the questions raised about military fitness tests as well. And the Marine Corps is still the one part of the military that does not have men and women trained together. And their argument is that it causes less successful military units by having the integration there. And that's going to certainly be a challenge in the future in our court system to say, is that an acceptable form of discrimination? Can women do all the jobs that men can do in the military? And if they can, is it still reasonable to have a form of discrimination against them? If they can't, then is it then an acceptable form of discrimination? Well, we've talked about segregation a great deal here. Let's turn our attention to unofficial segregation, what's referred to as de facto segregation. Is there any possible way to end this? So you can't turn to any particular law and say, this is the reason why these children are not getting the same opportunities as other children. No law is stating that. It just turns out that way if you do the statistics, that in some cities, let's just say, you have better opportunities for children of one race or ethnicity over others. But there's no law that keeps that segregation from occurring. It just happens that way through history, through economics, through culture. Is there ways to change that? And so what has possibly been used as the attempt to end this has been, one of the policy changes has been busing. So certainly read about that on pages 172 and 173. It's met considerable resistance. And it's interesting, again, to think about the 14th Amendment, equal protection under the law. Where's the equal protection of a child who may have to now be on a bus for 2 hours just to get to the school that's deemed to be the best school for that child in terms of educational opportunities? If the child is now using up a good portion of his free time just getting to the school, it's a fair question to say, and out of his neighborhood, is that really a fair way to treat that child and that child's family? But education is a key part in giving people opportunities to improve their lives. And so if you have some major differences in education within a community, there is then a very powerful question raised on how best to end that type of situation. And this is at least one of those ways of trying to end de facto segregation. Other forms of civil rights, universalization of civil rights, to say that there are other issues that need to be focused on in terms of extending rights for individuals, such as ageism. Is it in fact a proper form of discrimination to say to people as they get older that maybe they can't even have the opportunity to apply for certain jobs? And here you can look at what Barbie might really look like if she's now gone through the 50th anniversary of the doll. And so as a way of accepting that people will get older and what opportunities should be there for them when they get older. So there are places and there are jobs in which there are mandatory retirement ages, we can see here. And this varies perhaps in different situations, but it's been deemed to be acceptable forms of discrimination. It's discriminatory if you have a police officer that now turns 56 and can no longer stay on the job. It is, in fact, discriminatory, but it is an acceptable form of discrimination. The same for a military officer, the same for a minister, same for a judge. Notice that that's not for the Supreme Court, but perhaps for other justices, other judges. Pilots, there has been some challenges about this. You can see that they have to pass a physical every 2 years. So perhaps those physicals can get pretty demanding on them, and if they don't pass the physical, they can't stay there. And maybe that's the answer in some other areas as well, but it clearly says there are acceptable forms of discrimination. But we know that there's discrimination against young people as well. So many of you taking this class, you can't legally consume alcohol. And some of you taking this class, you can't go vote, even though you're paying taxes if you have a job and you have laws that you have to obey. You still can't vote. It is a form of discrimination. It's deemed to be an acceptable form of discrimination. There are, as we can see, as we expand the issue of equality, as we expand the issue of fairness, that we have other kinds of individuals in our society that we're left to question where should the extension of equality and civil rights go. Brittany Novotny was a candidate in the state of Oklahoma in 2010, and Brittany Novotny for the state legislature, she was a candidate for the state legislature. Brittany was in the transition of her life of going from a man to a female. And so when we think about this, this is not happening just in what we might think here in Oklahoma and California or New York City. It's happening in the state of Oklahoma. We have had a young lady graduate from an area high school a few years back named Katie Hill, and she had been, throughout most of her young life at that point, a male. And then she was transitioned into a female through surgeries and hormonal treatments. So we can see there that this is something that our state deals with, just like with any other state. What are the rights? What are the protections that should be there for individuals who are making these decisions in their lives? So on that issue, we can see our issues like that. In Lawrence v. Texas, declared unconstitutional a Texas law that prohibited sexual acts between same-sex couples. So this really deals with Fourth Amendment, Chapter 4 to some degree, the right to privacy, but it also certainly is focusing on civil rights. What are the civil rights for individuals in these situations? And if the act is, in fact, no longer deemed to be unconstitutional, in fact, it's unconstitutional to prevent the act or to make it illegal, then how can you prevent individuals, same-sex couples, from having other ways of signifying their relationship, such as a marriage? So as we can see here, certainly focus on these pages that deal with other questions raised about extending civil rights. For the Latino Americans, Mendez versus Westminster in 1947, you can read about that. Asian Americans, United States versus Wong Kim Ark. This is a case that's brought out on many occasions about the citizenship of children, babies that are born in the United States. This case declared that that was in fact the case, that all babies born in the United States were citizens. Well, the attempt was that Chinese babies born in the United States could not be U.S. citizens, but other children could be. Again, violation of the 14th Amendment, equal protection. Native Americans have a right to learn in their own native languages, and that was the basis of the case. Lau v. Nichols was involving Asian Americans as well. The disabled, as we can see there, read about the Americans with Disabilities Act and opportunities that are to be provided for people with disabilities as they go to school, as they try to have access to public buildings. The last couple of charts that we have here will focus on a key issue that I would imagine is interesting to all of you taking this class, and that is who should be admitted into college. And as you went through the admission process, or you're going through that admission process, you're thinking about where you go from NEO. Maybe some of you are concurrent students and you're wanting to get into a four-year college right out of high school. So where are you going, and what was the process like, and why do some people get in and other people don't? And that is always, I think, a very important issue, a major question. So in this cartoon here, you can see some of the possibilities or explanations as to why some people may get into a college and other people don't, and an individual who didn't get into a college, and then where does he direct his criticism of our system. And I think it's an interesting point made here from this cartoon. Do we think that the major reason why some people don't get into a college is because people of a particular ethnicity, they get in their place? But are there not other reasons why some people get in and other people don't, that perhaps don't fully explain the merit of getting into a university? So this started in the 1978, what was referred to as the Bakke case, 1978, pages 196, 197. Bakke, a white male, tried to get into University of California Medical School, was denied the opportunity to do so. And there was, at that time, a quota in the number of white males that would be accepted. So he sued, and I believe that was a violation of his 14th Amendment rights. The courts agreed to have a quota was unconstitutional. So he did, in fact, score higher than the average applicant into the medical school on his medical exams, and he had a higher GPA. However, the courts at that time did say that racial consideration was something that should be also part of the admission process. Is it in the best interest of schools to have individuals representing different races and ethnicities and different religions and different genders? Are we in a multicultural world, and should that be reflected in our education system? Well, at that time the court ruled that it was an acceptable consideration for admission. There's been some pushback to that area. On page 198, certainly focus on, as we can see there, what's called the Bollinger cases or the Michigan cases, both involving the University of Michigan. So Grutter v. Bollinger in 2003, Michigan Law School has a compelling interest to consider to create a diverse student body. So for the Michigan Law School to consider race for ethnicity at that time was viewed to be acceptable. For the undergraduate program, though, to have a point system, as you can see there with Gratz v. Bollinger, the point system for undergraduate program is similar to a quota system and is therefore unconstitutional. So there were a certain number of points that were not only dealing with race or ethnicity, but also location, if your parents, if you were the first one to ever go to college in your family, if you were from the Upper Peninsula, if you looked at a map of Michigan, see where the Upper Peninsula is located, those could be other reasons to get some points to be accepted. But it still ultimately was concluded by the court that that was unconstitutional. So again, we'll summarize by, again, the broader scope here. Civil rights centers on the rights of groups, and civil liberties centers on the rights of individuals. We're all individuals, and we're all parts of groups. What groups deserve some protections to ensure equality, some recognition by the courts to ensure equality, some other interpretation of the 14th Amendment, an ongoing struggle, an ongoing quest in our society to make that determination. We'll stop there. The next time we're together, we'll look at polling, chapter 6. And that certainly is a very interesting topic when you consider that we're right in the midst of a presidential election year. So until then, take care. If you have any questions, you know where to find me.